to introduce our panelists for this interesting discussion about hot topics in white-collar crime and government investigations. We have a really experienced, excellent panel today who are going to discuss the trends driving white-collar law in 2022. They will provide perspectives from the corporate law, in-house counsel, and government positions regarding the developments that are keeping them busy and up at night, and will provide tips on how to maneuver these increasingly challenging legal landscapes. Very pleased to introduce our moderator, Randy Jones, who is a member of the White Collar Crime and Government Investigations practice at our sponsor, Mintz-Levin. Randy is an esteemed trial attorney with experience representing public and private multinational corporations, their executives, special committees, and board directors in commercial and business disputes, investigations, and white-collar crime matters. He draws on his extensive courtroom experience as a formal federal prosecutor for nearly 30 years to provide value to clients, and has tried to verdict dozens of jury trials in both state and federal courtrooms. Randy, welcome.
Thank you, Rebecca, and good afternoon, everyone. Thank you all for being here for what we hope to be an exciting and an informative session here today. Again, a big thank you goes out to our presenters for their participation and insight that they'll get today. Everyone's going to bring a unique perspective on white-collar issues and trends, and our hope is that the conversation today will help you all frame some of the issues in your day-to-day work as a corporate counsel. Let me introduce, give you a little bit more information about the panelists who are joining me this afternoon. We have Meredith Ponce, who's the Vice President and Insurance Claims Counsel at Lockton Insurance Brokers, where she focuses on working with brokers and carrier partners to draft and interpret policy language. My good friend Aaron Arnzen at the U.S. Attorney's Office is the Chief of the Major Frauds and Public Corruption Section at the U.S. Attorney's Office here in San Diego, where he focuses on significant cases involving corporate embezzlement, securities and accounting fraud, insider trading, and stock manipulation. And finally, my esteemed colleague, Cynthia LaRose, who is visiting us from Boston, is the chair of the firm's privacy and cybersecurity practice, a certified information privacy professional in both the United States and Europe, who handles the full range of data security issues for companies of all sizes, from startups to major corporations. Before we kick off, there are two items for the audience. If at any point you'd like to ask a question of our panelists, you will be able to do so using the chat function in the right-hand corner of your screen. Just type that in and we'll try to get to them at a later point in the presentation. And for those of you who are joining us, make sure you get that CLE credit. There will be a CLE code that I'll provide to you later in the presentation. Before I go to the panelists, I want to show you what we have in store for you today. So our agenda today, we're going to have the 2022 outlook dealing with cybersecurity and cybercrime. Next, we're going to talk about trends in corporate enforcement and individual accountability. How to mitigate, the next part is how to mitigate risk of government investigations. And finally, white-collar investigations and D&O claims. After those remarks from my colleagues, myself and my colleagues, we will have a panel roundtable discussion, brief panel roundtable discussions, and then we'll open it up for questions. So without further ado, I'd like to turn it over to my colleague, Cynthia LaRose.
Thanks, Randy. It's nice to virtually join you and see everyone from San Diego. I wish I were there. Hopefully next time I will be. Hannah, if we can have the first slide. I'm going to quickly go through these slides, and that's a problem for me having starting me off first. Randy, you don't know what you're doing here, because I could talk for 2 hours on this. But from an in-house counsel perspective, I've had many discussions over the last year and a half to 2 years with in-house counsel regarding cybersecurity strategy as part of their governance and risk profiles. Remember, cybersecurity is not an IT problem. It is not anymore. It's an enterprise risk. So you should categorize that with all of your other enterprise risks, how you manage it, how you approach it. Here are some questions onto the questions that in-house should be asking about this cybersecurity risk. You don't have to be an expert, but you should be trying to get the answers to these questions, particularly the last question on here, which is strictly in your realm. What are the company's legal obligations with respect to data privacy and data breaches? That's going to be your key question. And that's the one that everyone's going to look to you for the answers to. So that's one of the things that you're going to need to deal with respect to cybersecurity. Next slide. So what's your role in all of this? IT certainly has a big role in it. And if you're fortunate enough to have a separate IT security group, they'll have a lead role in this. But as in-house counsel, you definitely have a role here. So how is the company likely to be breached? That's a conversation that you want to be having with IT and IT security. What are they seeing? What's the word out there? You know, you're not going to be paying attention to the alerts that go out from the various law enforcement agencies that deal with cybersecurity, but they should be, and those can have can provide a really good background into, you know, what you might be able to expect, or what kind of data you have, and how important is it. This third question here, have you developed an incident response plan, is really key, because this is your playbook. This helps to drive how you respond to an incident. And we've seen in our experience over the years that a bad response is sometimes worse than no response, because the bad response is what can end up driving potential lawsuits. So you want to make sure that you have a plan, and that the first time you're talking to people about, you know, service providers, outside counsel, forensics people, the first time you're talking to them is not after you get the call at 6 o'clock on a Friday night, usually the Friday night before a holiday weekend. That's not the first time you want to be talking to your team. What's your strategy with respect to ransomware? You need to have this discussion with your board, because it's I call ransomware the COVID pandemic of business. It's pervasive, it's everywhere, and geopolitical threats being what they are now, it's only going to get worse. So you need to have this on your radar screen, and have given some thought to what the company's strategy is going to be, depending on the facts of the situation. What's your situational awareness? And talk to IT, talk to your IT teams. There shouldn't be, you know, you only talk to them if you need help, if you need support. Communicate with them regularly. Could we have the next slide, please, Hannah? From your perspective, from legal's perspective, these are the things that your company should have in place. So these are the things you should be looking for, to see if they have them. A risk assessment. Has it been done? If it's been done, when was the last one? What's your third-party risk management? Because third-party risk is a big deal these days. How do you vet your vendors? What do your contracts say with respect to security, as it relates to your vendors? Do you have a written information security program? Unbelievable, you know, surprisingly, a lot of companies don't, but there are a number of state laws that do require that you have a written plan that outlines reasonable security. So that's something you should definitely be looking for. And if you don't have one, that's something to start to work on. And we talked about the incident response plan. That should be developed by management and approved by the board, so that the board understands exactly what the plan is and what the playbook is for dealing with this type of a risk. Next slide, Hannah. This is the question not to ask. And there is one question not to ask. Don't ever ask this question. Don't go to your IT people. Don't go to your security people and say, are we secure yet? Is it over yet? Are we done? Don't ever ask this question. And I'll tell you why. Next slide. It's the wrong question. Security is a never-ending process. Constant review and improvement. It's just not possible to create an absolute level of security. And by asking, are we done yet? implies that it is. So there are external changes all the time. You know, it's not possible. So the right question is on the next slide. And that way, when you've assessed your risk, when you've talked to the board, when you target acceptable levels of risk, then you can ask this question. How close are we? What else do we need to do? And I think I'll stop there. And if there are any questions coming up later, we can certainly talk about those. But to give everybody else time, I'll stop there.
Thank you, Cynthia. And I know my esteemed colleague can go on and on about this. This is an area of the law that she has tremendous expertise in the cybersecurity. And cybersecurity, as you know in the audience, this is something that, if not, it should be something that is of paramount importance to you. Because not only does it protect the business enterprise that you are secure from these attacks that you're going to get in all the time and invariably, but some of these things could be grounds for the government to come knocking. And so that leads me into my presentation about increased corporate enforcement and individual accountability. And so we all know that corporations can only act through as individuals, right? And in the past, corporations, if there were ever any sort of misconduct, it's usually on the civil side, and no one is looking at any sort of criminal charges. The corporation is not going to be held accountable criminally. Individuals not going to be held accountable criminally. And the corporation could dispose of the matter by, paying a fine and moving on with this business. Never really much of an interruption other than the internal investigation that you'd have to do in order to support your findings of fact, so that you could tell to the government, hey, look, there's nothing here. We've taken care of the matter. We'll take a fine and let's go on. But times have changed, and they've been changing for a while. So regardless of a corporation's disposition, whether the corporation is the matter against the corporation is going to be taken care of. Now what we're looking at is an increased increased evaluation of potential individuals who are charged with that. And the fact that you have a corporate resolution is not going to provide protection for criminal liability. Here I said criminal liability for any of the individuals in charge. And so I'd like to talk to you now just a little bit, just to give you a little background on the policies over the years that the Department of Justice has come up with respect to individual accountability for corporate misconduct. In 2015, Deputy Attorney General Sally Yates put out the Yates memo that said that companies, it announced under the Obama administration a policy that individuals and not just a corporate entity would be prosecuted criminally for corporate wrongdoing. So there was the memo spoke of an aggressive targeting of individuals as a top priorities, and companies were expected to fully cooperate in the government's investigation, both criminally and civil cases. And there was an all or nothing approach. They had to turn over all the evidence and information on culpable employees in order to be eligible for cooperation credit. So typically there'd be investigation, internal investigation, finding of those facts of that internal investigation would be turned over to the government, and then the government would decide whether or not you should receive any cooperation. But it was clear under the Yates memo that if a company wanted cooperation credit, you had to identify and disclose every person involved in the alleged misconduct. What we saw after that memo was really not a significant spike in criminal prosecutions or civil enforcement actions against individuals. However, it did change how companies approach both civil and criminal investigation. And then we move forward to 2018 under the Trump administration. Deputy Attorney General Rod Rosenstein wrote a memo. And in this case, it wasn't that the companies had to identify everyone that was involved in the alleged misconduct. This memo kind of softened it a little bit and said that companies were expected to identify the senior officials, including senior management and board of directors. Any executives who authorized the misconduct were also put on that list. Employees engaged in what they call routine activities of the company had nothing to worry about, even if they were involved in the misconduct. Companies only needed to engage in a good faith effort to determine who was substantially involved in the misconduct. The rationale behind that was to try to save government resources, encourage faster civil settlements, and lower costs for companies. As a result, as you would imagine, the number of Department of Justice criminal prosecutions and civil enforcement actions against individuals dipped. And then in 2021, just in October 2021, Deputy Attorney General Monaco issued a memo. And in this memo, it renewed the focus on individual accountability for criminal conduct of individuals. And the Biden administration has promised vigorous criminal prosecution of individuals in addition to corporations for white collar crime. And that's one of the priorities of the Biden administration Department of Justice. So what this means is that, the first priority is to find individuals to prosecute who commit and profit from corporate malfeasance. So that means top and bottom, rank and file. One key change in this memo that she mentioned, though, is that prosecutors are urged to be bold, and you'll hear from my colleague, Aaron Aronson, in a minute after I finish, but prosecutors are urged to be bold in prosecuting individual corporate executives, even if that means the government may lose some of those cases. Prosecutors are being told not to fear bringing difficult cases. The question is, will they follow this guidance? And you'll hear from Aaron, maybe he'll answer that question for you. But I can tell you, when I was in AUSA, I never feared bringing a case, a difficult case. It was all about trying the case and let the jury decide. But that's just me, I digress. I won't digress on that. Another point on the Monaco memo is that the DOJ has amended its principles of federal prosecution of business organizations to direct prosecutors to consider criminal, civil, and regulatory record of a company that is subject to a criminal investigation when deciding an appropriate resolution. So they're going to look at all your past behavior in deciding what would be the appropriate resolution of this case. And the major result of this change is that companies under investigation by DOJ should be prepared to conduct more fulsome internal investigations to identify all wrongdoers and provide all the information they learned about their alleged misconduct and make a disclosure which could lead to increased investigation expenses. And so we've already seen this in play. There's already been an increase, next slide please, in the number of convictions and trials for individuals. In 2020, there were only 213 convictions of individuals. In 2021, it rose over 50% to 329 individual convictions. Also, in 2020, there were only 16 trials of individuals where individuals were convicted of corporate misconduct. In 2021, that's already doubled to 30. And we anticipate that that's going to increase. And the reason that we think that that's going to increase is because the government has requested and received an increase of its budget. The DOJ has a budget of $36 million. They've added hundreds of federal FBI agents, and the fraud section, which is tasked with prosecuting these corporate malfeasance or misconduct, they've added 34 additional attorneys. If there's one bright spot, if you will, for companies, is that we saw a decrease in the number of corporate resolutions in 2021. In 2020, there were 13 corporate resolutions where the government got over $9 billion in fines from the corporations. Last year, we saw that decrease to only 8 resolutions, and the government still recovered about $3.3 billion in fines. Now, that doesn't mean that there won't be civil resolutions of matters, and that number is expected to rise. So the key takeaways from this point that I want to leave you with before I turn it over to my colleague is that we can expect, or you can expect, or companies and corporations can expect, that there are going to be more civil in criminal enforcement actions taken against companies. There's an increase in individual responsibility. So from top to bottom, rank and file, individuals, executives, members of your board of directors, things of that nature, people who make the decisions that the government considers to be fraudulent or involved in any misconduct are likely to be looked at for responsibilities and accountability. The government's also going to expect that companies fully cooperate if they want to get any sort of credit for cooperations. And that full cooperations means that they got to identify and turn over the individuals, the names of the individuals that they believe were involved in the misconduct. And then finally, I think one of the other things, corporate monitorships are going to be back. So that might be something that companies are going to have to look at in the future. So that's where we see with respect to corporate enforcement and individual accountability. I'd now like to turn it over to my former colleague, Aaron Aronson, to talk about how you can mitigate the risk of government investigations.
Hi, all. Thanks so much, Randy, for passing the baton. Before I get started, because I work for the government, I have to give a disclaimer. What I say now is just my own view. It hasn't been vetted by anybody at the Department of Justice or the U.S. Attorney's Office. They are not the views of those institutions, rather my own views. So with that, I can talk about mitigating the risk of government investigations, mostly by letting you know what our focus is these days. And so if you know what we're focused on, then you can create strategies to mitigate the risk that you'll come under investigation or that those investigations turn out poorly. One of the things that we're absolutely kind of being instructed to focus more on these days is fraud that involves government funds. And so every time you see a pretty significant increase in the governmental budget, especially toward programs. You see that in changes of administration from time to time. You see it in response to, a global pandemic. You're going to see an increase in the budget. And if you see an increase in the budget, you can expect another effort underway with law enforcement to make sure that those dollars are well spent, but even more importantly, they aren't used to commit fraud, or they aren't taken in terms of in conjunction with a fraudulent scheme. So I think it's fair to say that we have seen over the last few years programs that have received extraordinary funding from the US government. That funding, the programs, ultimately the dollars go out to the public. They go out to businesses and individuals. And so you can expect, and this has been in speeches by department management, you can expect a focus by the Department of Justice, by my US Attorney's Office and the fraud section, to concentrate on grant fraud. In other words, if companies are receiving government grants to further research or further some sort of commercial effort that's consistent with the public interests. If there's fraud associated with that, there's going to be a closer look at that fraud. And it used to be that it had to be a fraud that stole a whole bunch of grant money or misdirected a whole bunch of grant money. But what directives like the ones we're receiving these days do, among other things, is bring down that threshold. So it doesn't have to be a huge grant fraud in order for us to get involved. It now can be something somewhat short of a huge grant fraud. The same thing takes place in the procurement fraud context. We use this term a lot. I hope it's clear. What we mean by that is if, for example, there's a defense contractor who supplies goods to the military. They clearly get government procurement funds, and they supply the government in turn with goods and services. So when we talk about procurement fraud, we're talking about government dollars being spent to pay for goods and services. And we often find a lot of fraud in that area. I mean, there are tons of good actors doing good work. There are too many fraudulent actors in that space too. And the same thing holds true here. There's been increase in procurement funds being allocated by the Congress and the federal government. So in turn, we're being instructed to pay more attention to this area. It doesn't happen with just defense contractors, though, of course, it happens with all sorts of businesses that supply other goods and services to the government. And another area, and this may touch on some of the audience members, it may not, but if you are in a space, in a business space that has anything to do with CARES Act funds, EDD, which is the Employment Development Department here in California that has the unemployment insurance program under it, payroll protection programs, EIDL loans, which are another form of economic incentive established by the CARES Act. Those are lately the highest area of focus for us. Those are usually frauds committed by individuals under the CARES Act, but there's certainly room for corporate malfeasance when it comes to CARES Act funds. The CARES Act was the huge stimulus. It's actually a sequence of stimulus packages that were gargantuan, billions and billions of dollars. And there, I should probably say over $1 trillion is accurate. We have found billions across the nation, billions of dollars of fraud associated with CARES Act stimulus funds. So we are being sternly instructed to make sure we take a very close look at that. If your corporation, if your organization is somewhere adjacent to or a recipient of or a processor of funds that are affiliated or somehow associated with the CARES Act, you can expect increased attention, at least, especially if things go wrong. I wonder if I could ask for the next slide, please. Another thing that we've been instructed to focus on, and it's an interesting way to look at it, and it should be obvious that we always take victims into account, but I think you can look at a track record over the last several years and you can detect an increased focus, not just on the bad guy or the bad organization, but also on victims. Madoff is an interesting case. It's not being handled in this district. It's being handled in the Southern District of California. I'm sorry, Southern District of New York. After years and years and years of efforts to recover funds on behalf of Bernie Madoff's victims, the receiver in that case, which is a court-appointed receiver to try to go after funds, has now gotten back 80 cents on every dollar lost by Madoff's victims. That is a gargantuan recovery. If somebody said that a week or two into the Madoff Ponzi scheme, as it was kind of played out in the press, no one would have said you're going to get 15 cents back. So 80% back is huge. It demonstrates a concerted effort not only by the court-appointed receiver, but also by civil forfeiture AUSAs in the Southern District of New York, who do work still all these years later every day on that case. That to me indicates a very intense focus on victims. That's coming to the fore these days. If you listen to statements by department leadership, including the Attorney General himself, he tells the world that we're going to concentrate more on victims. Our own district here in Southern District of California, San Diego, we recently brought a case against a guy who ran a Ponzi scheme. It might as well have been Bernie Madoff, except the guy pretended that he was taking in investor money and he would invest it in a cryptocurrency, and the cryptocurrency and the associated investment programs were just, a smokescreen. None of it was there. The guy lived in India at the time, traveled throughout, but he raised $2.4 billion through this Ponzi scheme. The United States Attorney's Office, in conjunction with the fraud section at Maine Justice, we recently recovered a bunch of Bitcoin and turned that Bitcoin into cash through an interlocutory sale of the Bitcoin to preserve it for purposes of victims. That to me also indicates a strong interest in making victims whole. We have an intense focus right now on not just paying attention to the bad guy again, but also paying attention to victims. I'll tell you a very brief story about this one. Sony has a subsidiary, Sony, the multinational conglomerate in Japan, with a press of the button in last year, lost $155 million. There was an insider at the company who redirected a transfer of funds into a Coinbase account, immediately turned it into crypto, and immediately put it on a cold wallet, which is off the network device. Through some intensive investigation, the FBI here in San Diego tracked all that down. The bad guy's in Japan. He's in custody in Japan right now. We worked intensely with international law enforcement partners. And what's important about this one is we found the crypto, and there's a press release on that. It was Bitcoin, and we turned it back into cash, but we worked with all parties involved to make sure, I don't know if anybody's seen the Bitcoin value chart over the last 6 months, but it is like a roller coaster. So we worked in order to make sure that we did this at a time and in a manner that got as much of that original value back to the victim as possible. The victim lost $154 million, and the sale of crypto, because of the way we did it, resulted in a recovery of an even greater amount because of the fluctuation in Bitcoin. So knowing that we're focused on victims should tell the people in the audience that if you service the public in some way, in a very broad way, say a bank with a bunch of customers or a brokerage firm with a bunch of customers, there are a bunch of potential victims out there that will lead to greater scrutiny if the misconduct that we find affects a great number of victims. I wonder if I could just have the last slide of mine, please. Here might be, if there is an interesting point that I can make today, it might be this. I do a lot of thinking about corporate liability vis-a-vis individuals, and Randy absolutely has the details right. I wouldn't go back and correct a word of what he said. What's interesting to me, though, is from a government investigator perspective, I can tell you that the corporations land in such a better place if they have a very highly developed compliance program. I can tell you a very brief story that demonstrates the counterpoint. I was at the SEC in New York for several years. I was in Bernie Madoff's offices digging through the files after he confessed to his Ponzi scheme. I found in Bernie's brother worked at the firm. Bernie's brother's name is Peter Madoff. He was the chief compliance officer at Bernie Madoff Investment Securities. Peter had stacks and stacks and stacks of compliance programs. He had well-developed compliance policies and procedures and the whole bit. And not one of those was ever implemented. Nothing. Because of course it wasn't. It was in the midst of the world's largest Ponzi scheme ever. What a good compliance program would have allowed us to do is very easily identify who had to lie to the compliance program, who had to go around the compliance program, who had to make misrepresentations. And then it would have steered us toward the individuals who also helped Bernie commit the Ponzi scheme. Because the compliance program was just paper, the only thing that thing established is Peter Madoff's liability himself, right? He told everybody that there was a compliance program and there wasn't, and he's finishing up right about now 10 years in prison for it. But what it could have done is allowed us to prosecute it would have facilitated the investigation of all the other people that helped Bernie. So let me apply this broadly. If we walk in an investigation figuratively, and we figure out that there's a very good compliance program, that not only helps the company say, no, we're doing what we should to help the company follow the law. We have a couple bad eggs, but the company's good. It's got a great compliance program. We review it all the time. If that's the case, then it helps us focus on the individuals and the corporation's in a much better spot in terms of potential criminal liability. So it helps the company stay protected. It also helps us with our investigation. I say compliance, so that's if there is an interesting point, I find that to be the most. But the thing that I meant with compliance writ large is this. We find that once a compliance program is built, you know, in the first instance, they're often built well. But to go back to Cynthia's point, are we secure yet? Because it's a changing landscape and a changing world all the time. That compliance system has to change with the situation, with the times, with the environment. And I make that point in connection with this discussion because, you know, if it's up to date and if it's a good system and it's changed over time with the environment, it helps both the investigators and the corporation. So that's what I had on that, Randy.
Okay, well, thank you so much, Aaron, and thank you for sharing your personal experiences and some of the cases that you've been involved with that really brings to home what it is we're trying to get across today. So thank you for that. Next, and finally, we'll hear from Meredith Potts, she's in-house counsel, so she's one of you guys in the audience, and she's gonna talk about white-collar investigations and D&O insurance claims. Meredith?
Thanks, Randy. Yeah, so I'm here to talk about sort of what are the insurance implications for these white-collar investigations. And really, when we're talking about that, we're talking about directors and officers policies. So here, this slide's got sort of just the basic structure of a directors and officer policy. And just to go over it, coverage A is the personal asset protection. And so that is what protects your directors and officers against any loss that's not indemnifiable. So that's claims for which the corporate entity may not or cannot indemnify individual directors and officers. And there's some examples below there. Coverage B is the corporate asset protection. So that is reimbursement to the company for indemnification that they may have given to directors and officers. And coverage C is also corporate asset protection, but that is for entity-specific claims. And for publicly traded companies, those are limited to securities claims. So when we're talking about these white collar investigations, we're really looking at the coverage for the individuals. So coverage A, coverage B. And so Hannah, can we go to the next slide? One thing to keep in mind with directors and officers policies is that they are claims made policies. So that means that the claim needs to be tendered to the insurance carrier during the policy period in which it is made. So that sort of brings the question for in-house counsel of, well, what is the trigger then? When is this coverage triggered? And so there's some standard triggers that you find on a D&O policy or really on any management liability policy. And that would be, you know, written demand for civil monetary or civil non-monetary relief. That essentially can be a lot of things, but really attorney, you know, letters from counsel, that type of thing, you want to definitely forward those over to your carrier. Also civil proceedings, administrative proceedings, and then the criminal proceedings against an insured person, which here we're talking about sort of directors and officers. Hannah, can we go to the next slide? So the previous slide had sort of the traditional triggers, what, you know, sort of the obvious ones, I guess. This slide has more of some additional triggers that you want to keep in mind, especially when we're talking about white collar investigations. And so triggers can also include a formal order of investigation from a civil or administrative authority, a Wells notice from the SEC, a target letter. If you get any of those, you definitely want to alert your carrier. And then the second category here is one that the language can vary a lot by policy. So, you know, this language here is just an example. You want to consult your own policy, but oftentimes these D&O policies have what's called a pre-claim inquiry trigger. And so that can be, it's a verifiable request for an insured person to appear at a meeting, interview or deposition, or produce documents that concerns that person's insured capacity in the business. So that is a broad category. A lot of things can fall in there, and they can be sort of informal. There's no requirement here that it be a written request. It just needs to be a verifiable request. And it can include requests from regulators, boards of directors, or a committee thereof in connection with an investigation by a regulator or derivative demand, court-appointed trustee in a bankruptcy proceeding. What's notable about these pre-claim inquiry triggers is that they don't necessarily require a wrongful act. You should consult the language of your policy, but oftentimes they don't. So again, you know, any kind of informal request, you may, if you get one of those, you may want to send it over to your broker or to your carrier, just put them on notice of it. And then can we go to the next slide? Oh, one back. So let's say, you know, let's fast forward. You've sent it into your carrier, this white collar investigation. Now there's a question of what constitutes loss under a D&O policy for these types of things. There's sort of the obvious damages, settlements, judgments, and defense costs. Those are sort of obvious for your policy, but then there's also the pre-claim inquiry costs. And that is, again, why you want to get these matters sent in as soon as possible, because those can include reasonable fees, costs and expenses incurred by or on behalf of an insured person in connection with preparing for or responding to a pre-claim inquiry. So, you know, in terms of these white collar investigations, that can include a lot of document review. It can include, obviously, your attorney's fees for getting your insured person prepared for this interview. If you need forensic accounting, those types of things. So one thing to check with consult with your policy or with your broker for these is just oftentimes there can be an element of consent by the carrier. So you may want to run these costs by the carrier before you start incurring them. But they can be substantial costs. And so, you know, if you have insurance available, D&O insurance, you definitely want to take advantage of getting some coverage for these costs while you're going through this white collar investigation. And then finally, does loss include fines and penalties? You know, say the investigation wraps up, there's some degree of fines and penalties that are assessed. The answer to that is every lawyer's favorite answer, which is it depends. Depends on whether or not the fines and penalties are civil or criminal in nature. Depends on whether they're assessed for intentional or unintentional conduct, and also depends on whether they're insurable under applicable law. So when you're thinking about these things, it's definitely important to look at the language of your policy, look at the facts that are presented, and of course, look at the applicable law in the jurisdiction where the investigation is taking place. And so that's it for my part, Randy.
All right. Well, thank you so much, Meredith. We appreciate that. And as I said at the beginning, if you have a burning question you'd like to ask, just drop it in the chat. But for now, we're just going to, I want to ask each panelist a question or so while we have a few minutes left here. And I'll start first with you, Cynthia. What types of companies are specifically prone to cyber attacks right now? And are we seeing one particular industry being targeted?
All of them. All of them. There's no, there are certain industries that have been more susceptible lately to targeting than others, mostly because of the type of information they have. Healthcare, the healthcare sector has been especially hard hit by ransomware. Think about the information that a healthcare provider or a large healthcare institution has on every individual patient. So it's particularly, that's a particularly juicy target for folks. It's also healthcare, the vulnerabilities of the healthcare system and the way they utilize technology or don't, particularly security technologies, has also been put on some display with the ransomware attacks. But you know, it's really across every industry sector, every size business. Don't tell me that your company's too small, because it's not.
Okay. So how would you recommend that the in-house counsel on our call today in this webinar keep track of the changing legal obligations related to privacy and security?
Take advantage of groups that are out there that it's their job, it's their mission to stay on top of these things. Make friends with your local industry groups in law enforcement. They're called ISACs, and they're great places to keep in touch with what is going on in your specific industry. The FBI puts out advisories. CISO, which is part of the Department of Homeland Security, puts out advisories. You can follow people like, shameless plug here, Mintz, and our 50 state survey of data breach notification laws. We try and keep those as current as we possibly can to keep up with the changing views. There are going to be now 4 more, soon to be 5 more new laws hitting the books next year, effective in 2023, including new updates in California, by the way. So places like that are good places to try and keep. You're never going to be an expert, because that's not what you do. That's not your day job. But at least to sort of keep on top of what you should be asking your own internal folks. Some of the security, the big news about security vulnerabilities. What are we doing? How are we doing this? Are we patching? Do we do these sorts of things? These kinds of following these types of organizations, and just getting on their newsletter lists and scanning headlines in the morning is a good way to sort of keep a finger on what's happening. That's the only way, because it's just changing too fast. Mm-hmm. And we see it, that's our job. And at times it's a bit overwhelming.
Thank you. Thank you, Cynthia. Aaron, you talked about, corporate versus individual liability and the Department of Justice policies. I know I mentioned those in my presentation as well. How much of an impact does it have on a case-by-case basis when the guidance on corporate versus individual liability is changed or revised?
It has some impact. Listen, the overall nature of the factors that we're instructed to consider, and they're public. They're in the Justice Manual. You can find the Justice Manual online. It is determinations with respect to corporate criminal liability. Those don't change. Those don't change except at the edges. And so Randy was absolutely right on with respect to kind of distinct guidance that comes out from time to time. But the fact is, it doesn't change the structure all that much, or the factors all that much. I don't mean to make light of it, but if you're on like Wheel of Fortune, it's if you're really close to the tick and it ticks over to the other side, maybe in those really close cases, it makes a difference. But what really makes more of a difference is the focus and the types of crimes that the department leadership tells us to focus on, I think is the succinct answer to that question, Randy.
Well, let me follow up with another question. You spoke a lot about your experience, and again, thank you for sharing your own experience as a federal prosecutor with us. What would you tell the in-house counsel on today's call, what the number one mistake that corporate leaders make that leads to investigations or enforcement actions by the Department of Justice?
Probably going to sound like a broken record because Cynthia said the same thing. You have to keep up. You live in a changing world. I find that especially true, and I find a lot of investigations that focus on periods of time when these businesses go through very significant transitions. So especially, for example, if it's a growing business, if a business was a small size business and all of a sudden it's a rather large, medium sized business, or jumps to a very large business or even multinational, and that transition happens quickly, it's often really hard to slow down and make sure your compliance programs, your internal controls, your cybersecurity is up to speed and coming along just as fast. So it's paying attention to all the risk factors that are changing when your business goes through a really dynamic and significant change.
Yeah. Thank you. Meredith, you talked about the insurance market. So as an in-house counsel and as someone, talking to your colleagues, who are also in-house, what type of conditions are you seeing in the cyber insurance market that we should be concerned about or aware of?
Yeah, the cyber insurance market has been definitely in a state of turmoil over the last few years. And it's really, we're seeing a lot of increasing retentions, lower sublimits, lower limits in general, higher premiums. And then we're seeing a lot of coverages even getting cut. For example, like cybercrime, the social engineering coverage, that is hard to come by these days. It's the underwriting process is extremely difficult now. And I mean, even to be underwritten, you essentially have to have controls in place like MFA and dual MFA. You have to jump through a lot of hoops now just to qualify for cyber insurance. And then what you are going to be presented with as options is probably not going to look like the kind of options that you had several years ago.
Mm-hmm.
Call it a cyber colonoscopy.
Yeah, it's a good way to describe it. It's not the most pleasant underwriting process these days.
All right. Well, Erin and I talked about, this whole notion of how policies change within the Department of Justice, depending on the administration. Has the D&O insurance industries, or let me just ask you this question, how have the D&O insurance industries concerns shifted since the previous administration? In other words, is there anything that carriers are more concerned about under the Biden administration that they weren't under the Trump administration?
Yeah, I think we're seeing definitely an increased interest from the D&O underwriting side on ESG. That's something they're paying a lot of attention to. A lot of interest in watching sort of what's happening with disclosures related to cybersecurity. There've been a string of announcements over the last few weeks of new requirements for disclosures. The D&O industry is watching that very carefully. And then one of the things they've really been paying attention to a lot lately is SPACs and de-SPACs and those types of transactions. That's something that also has their attention, and they're watching that market and watching the claims starting to trickle in on that. And that's also a tough vertical to be in for underwriting.
Well, thank you for that. I don't see any questions in the chat. So in the 5 minutes that we have left before I give out the code, Cynthia, just go through one day. Any closing remarks you'd like to make?
Think about, for in-house counsel, thinking about having these really important conversations with your IT folks and your security people, so that you know where the company stands. Everything that Erin and you all have said about compliance goes into cybersecurity as well. It's an enterprise risk. So you need to know where your company stands on the risk scale in order to be able to help to manage that. And that is part of in-house counsel's job, is to help them manage the risk. And it's definitely a risk. I mean, we are seeing more and more of it. We're seeing more and more ransomware. And by the way, since ransomware is primarily Russian state actor sponsored, it is unlikely that even if you have to pay a ransom, that you'll be able to now.
Mm-hmm. Good point. Erin, any final thoughts?
The whole discussion about when the government, especially the criminal investigators, get involved with corporations, I come with some perspective. I realize that that's just a frightening thought, an overwhelming thought. It happens not frequently, and not with most corporations. It's when something pretty bad happens that gets past the regulatory space, so it's a mere regulatory violation. The way to keep up with it again is, keep on going back and asking to first principles of the compliance function, like what could go wrong here. And if you keep on doing that, it's likely that we're going to go not to you, but the bad actors out there.
Yeah. And finally, Meredith, you have any closing remarks you'd like to share?
I would just, from the insurance perspective, it's always recommended to get familiar with your policy, take a look at what triggers, what's covered. From the cyber insurance perspective, definitely you might want to get familiar with who the vendors are that your carrier is willing to use. Set up times to chat with them before you have a breach. Like Cynthia mentioned, it's always better to get to know them ahead of time than on a Friday, late Friday before, Thanksgiving.
All right. And on that note, I want to thank my distinguished panelists, Cynthia LaRose, Aaron Arnzen, and Meredith Ponce for their presentations today and participation. And I also want to thank Rebecca and Audrey on behalf of the ACC San Diego chapter for having us here today. It was great. I hope that you in the audience have heard something that you can use to help you be more effective in your roles and your position as in-house counsel. And before we say goodbye, for what you've all been waiting for, the code. The CLE code is 6537. 6537. And with that, if there are no questions, I don't see in the chat, we want you to thank you all for joining us today and have a great rest of the day and the rest of the week. Take care.
Everyone.
Bye-bye.
Thank you. Bye-bye.